Alistair Carmichael.
Thank you very much, Mr Hosie. Amendments 19 and 20 standing in my name again have their genesis in the efforts of the Law Society of Scotland. They seek to achieve much the same ends as those which have already been outlined by the Honourable Gentleman from the Opposition front bench and from the Honourable Member for Murray. I think, as things stand, on a very literal basis, the clause that is before the House is one that does implement the Sewell Convention, and that is why the word normally is in there. When Lord Sewell, in the other place, in the course of the proceedings for what then became the 1998 Act, gave that undertaking, the word normally was what was used. But as I think has become apparent from the comments from the Honourable Member for Murray and others, the operation of that convention, as it has been done in practice over the years, has been very, very different. We now have Devolution Guidance Note number 10, and I think that it is, on reflection, having had the benefit of pre-legislative scrutiny, appropriate that it should be visited again in the terms that are before the House tonight. And I don't necessarily expect the Secretary of State to accept the amendments that are before us this evening, but I do hope that he will acknowledge that this is a legitimate point, a point which frankly costs nothing for the Government to take a different approach, and that it would be an indication of them listening and an indication of their goodwill as they approach the proceedings on this bill. In relation to the new clause brought forward by the Honourable Gentleman from Nottingham North, I enjoyed the trailer of the second reading speech for the Human Rights Act abolition bill, if we are ever to see it. It was notable, of course, that it was not in the Queen's speech, and I hope that, having looked over the abyss and having seen the myriad of complications that would come now from the course of action that is proposed by the Government, they may find that this is an area where extensive and very mature consideration is necessary, and in fact we might never actually see that second reading debate happen. I hope, because in fact to bring it back to its relevance to the bill that is before the House, the purpose of this bill is to cement and to protect the integrity of the United Kingdom and Scotland's position within the United Kingdom as a single constitutional unit. I have to, if I can maybe just expand the thought, and then I'll take the Honourable Gentleman's intervention. In the event that we were ever to have a proper federal written constitution, the Human Rights Act, I think, would be part of that at a federal level. There's absolutely no doubt in my mind about that. And to try to have a different regime of something that is as fundamental in its character as the Human Rights Act and indeed the European Convention in different parts of the United Kingdom would be another thing that would put a stress on the fabric that holds us together as a constitutional unit. I'll take the Honourable
The draft of a written constitution done by the Political Constitution Reform Select Committee includes the Bill of Rights, obviously. I thank the Honourable Gentleman for giving way. My point to ask him is that, in fact, the abolition or change of the Human Rights Act is in the manifesto of the party who now forms the government, and therefore they may feel they ought to bring it forward. But can I ask him to reinforce his point that good pre-legislative scrutiny, just as we're proving this evening, on something as technical and detailed as that, will prove to be an immense bonus to the government itself in getting through anything that it proposes in this field?
Indeed, that is the case. Of course, for all sorts of reasons, pre-legislative scrutiny is not always possible, but it ought to be the default in any sensible legislature. And, as I understand it, and the Secretary of State may intervene on me if I'm wrong here, I think the Government have already said that they will not change the integration of the Human Rights Act in the Scotland Act of 1998, and that the Human Rights Act will continue to be the underpinning of the Scottish Parliament. So inevitably, any change that were to be brought forward would be one which would not apply to Scotland, and although conceivably you might be left with a very messy situation in Scotland where you would have a Human Rights Act apply in relation to some matters and not to others. I was practising in the Scottish courts as a solicitor when the Scotland Act came into force, but before the Human Rights Act came into force across the whole of the United Kingdom. It left us in a situation where we used to have a device known as a devolution note in relation to human rights matters if you wish to raise them in a court. It was messy. It got us through the year that was necessary, but I don't want to go back to these days. I think having a single regime of human rights protections applies across the whole of the United Kingdom. It is something that is absolutely necessary, and we tamper with it at our peril.